The panelists were having very fruitful discussions. No doubt, Pakistan is lagging behind for international arbitration forums and for the forums to resolve the disputes, commercial disputes of international levels. And I anticipate that now the government will show sensitivity and will make arrangements to bring venues of international repute and international forums for resolving international disputes. My Lord, former Chief Justice Pakistan, Mr. Tasadduk Hussain Jilani, rightly raised issue about capacity building and lack of homework, particularly referring to the litigation of Rekodik case. Yes, of course, all the lawyers have to come prepared to the courts and have to take their briefs with complete homework. And if a lawyer has not completed his homework, it pays a lot to the litigant. As I mentioned yesterday, we don't have any academy for coaching of the judges of the high courts. So my suggestion is, and I will make a request to this forum, to Chief Justice of Pakistan, to the Ministry of Foreign Affairs and to the Ministry of Law and Justice, that they should manage training sessions of the judges as well as advocates in different countries, particularly to Judicial Academy of Singapore, Judicial Academy of Washington and academies of UK, so that capacity building is improved for the judges as well as the lawyers for resolution of the international disputes. A very sensitive issue was raised by the panelists as well as audience about corruption. And all were bold enough to quote the instances of corruption. My belief is that a God-fearing person cannot make corruption. And if any person, either in judiciary or in government service, is involved in corruption, he is not a God-fearing person. And if a person is involved in corruption and he has no fear of God, then let us put him to the fear of severe punishment. Unfortunately, we have NAB law, we have anti-corruption laws, but they are not providing adequate punishment. I am putting a question to the House: why the anti-corruption laws have not been revamped? We are dealing in anti-corruption cases before the special courts in central anti-corruption or provincial anti-corruption, decades-old laws which are not providing adequate punishment, which is deterrent. Similarly, why, while promulgating National Accountability Ordinance in the year 1999, why the NAB has provided punishment up to 14 years? Why not death penalty? And why two windows were left open, one for plea bargain, the other for voluntary return? Because the legislator himself is not serious to eradicate the corruption, and he is conscious that I am making the law, tomorrow may I myself be subject to that law. So the doors and the windows have been left open with regard to plea bargain or voluntary return. I may tell you that for the last 12 years while working as a judge of the High Court, I have dealt with number of cases in appellate stage with regard to the trials of the accountability courts. And in 3 classical cases, I provided maximum provided sentence of 14 years, and I wished, had there been death penalty, I would have awarded death penalty. And if there was a death penalty for the charge of corruption in Pakistan, I think it would have caused a lot to eradicate the menace of corruption from Pakistan. Now, in view of recent amendments in the NAB ordinance which are under challenge in the Supreme Court, numerous cases of accountability courts have to be reverted back to the anti-corruption courts, where we don't have any adequate mechanism. The prosecutors are not so trained, the investigating officers are not so trained, even the judges dealing with white-collar crime have not been provided any specific trainings. What we are doing? We are assigning charge of special court of accountability to district and session judges. We are assigning charge of special courts anti-corruption to session judges. Session judges are dealing with criminal cases on the basic principles of extending benefit or doubt to the accused, whereas in white-collar crime cases, judgment has to be written with altogether different prospects. The principles for appreciation of evidence in a criminal case, the principles for appreciation of evidence in a civil case, and the principles for appreciation of documentary evidence in a white-collar crime is altogether different. But in my country, no mechanism has been provided for training of the judges to write judgments of white-collar crime. We, the judges, are doing our best to maintain the rule of law. In Balochistán, we have taken disciplinary actions against the judges who were involved in corruption. Even senior most session judge was removed from service on the charge of corruption, and our MIT mechanism is working very efficiently and is monitoring the performance of the judges of the subordinate courts. So lawyers have to make themselves self-accountable. They have to maintain the ethics and values of the profession. We are providing vocational training to the advocates in Baluchistan Judicial Academy for the last 2 years so that their capacity may improve. We are playing our part. You should also play your part. So in the end, I am thankful to the audience for providing all love, respect and affection to me. And in the end, I will say that we all should continue and strive hard to uphold the rule of law for a better and prosperous Pakistan. Thank you very much.